Right out of the gate, this case takes an unexpected turn. A nearly 60-year-old veteran walks into court facing a felony drug charge tied to methamphetamine possession, but instead of immediate prison time, the court starts discussing something called intervention in lieu of conviction, or ILC. That's a huge deal because it means the judge is considering rehabilitation over punishment. But here's the catch: one wrong move, one failed drug test, one violation, and this guilty plea could instantly come back to haunt him. You can already feel the tension building because this isn't just about a criminal charge anymore, it's about whether this man can convince the court he deserves another chance. And wait until you hear what happens when the conversation shifts from prison and probation to an electric bike sitting outside a motel. Trust me, this hearing goes somewhere nobody expected.
Mr. Caldwell is prepared to enter a guilty plea this morning to one count of aggravated possession of drugs, felony of the 5th degree, in a single count indictment. My understanding is that he is eligible for ILC and is a good candidate to be referred to the Veterans Honor Court. State has no objection to that.
All right. Mr. Elter, is that accurate?
Yes, Your Honor.
Okay, Mr. Caldwell, they're telling me that, well, your attorney had filed a motion for intervention in lieu of conviction, so in a moment you'll be asked to change your plea to guilty to the one count of the indictment. The court accepts your plea but does not make a finding of guilt. Instead, I will order this case to be just set aside, and you'll be required to complete a plan of intervention, which if you successfully complete that plan of intervention, then the prosecution of this case will end with no finding of guilt, and I will dismiss this charge against you. Do you understand that?
That's the ILC you're talking about, sir?
Yes, sir.
I've done it before and graduated with honors.
Okay. However, if you don't complete the plan of intervention, if you continue to use illegal drugs or break the law, then the court will be able to make a finding of guilty that's based on your plea today, and then I'm going to sentence you accordingly. Do you understand that?
Yes, I do.
How old are you?
I'm going to be 60 this month.
How far did you go in school?
2 years in college. I'm sorry for getting emotional.
Can you read and write okay?
Yes, sir.
Are you a citizen of the United States?
Yes, I am.
Does anyone promise you how the court would sentence you in this case? Promise you?
No.
Has anyone threatened you in any way to get you to plead guilty against your will?
No.
Are you satisfied with the representation you've received from Mr. Elter?
Yes, I am.
Are you currently under the influence of any drugs or alcohol?
No, I'm not.
Do you take medication that interferes with your ability to understand what's going on today?
No, I don't.
I have in front of me a document. This is called a change of plea. On the second page, on the line marked defendant, there appears a signature. Did you sign this?
Yes, I did.
Did you read this and go over it with Mr. Elter?
Yes, he did.
Do you feel like you understand what it says?
Yes, I do.
All right. This document says you're running a plea of guilty to one count of aggravated possession of drugs as a felony of the 5th degree. That carries a maximum penalty of 12 months in prison and a maximum fine of $2,500. The prison term is not mandatory. Do you understand the maximum penalty?
Yes.
You're also subject to a discretionary period of post-release control.
This section right here is one of the most important parts of the entire hearing because the judge is carefully laying out every possible consequence before accepting that guilty plea. A lot of viewers hear rehab program and think the defendant is simply getting off easy, but legally, that's not what's happening at all. Mr. Caldwell is essentially walking a tightrope. If he successfully completes ILC and follows every condition, this case could disappear without a conviction. But if he slips up, the court already has the guilty plea locked in and ready to go. No trial. No second debate. Sentencing could happen immediately. And notice how detailed the judge is being here: prison exposure, probation violations, post-release control, even future felony consequences. That's the court making absolutely sure the plea is knowing, intelligent, and voluntary, so there's no argument later that the defendant didn't understand. The emotional moment where Caldwell says he's almost 60 years old also changes the tone of the room completely. Suddenly this stops feeling like just another routine drug case. Do you think courts should prioritize treatment programs like this for nonviolent offenders, or should repeat drug charges automatically lead to prison time? Let me know in the comments.
Which means if you are sent to prison on this charge, when you are released, the adult parole authority may choose to supervise you for up to 2 years. If you violate that supervision, the adult parole authority can return you to prison for up to 1/2 of this court's original sentence. If your violation is that you commit another felony, you can be returned to prison for 1 year, or the period that you have left on PRC, whichever is longer, and that time would run consecutive to any additional prison time that you get sentenced for. Do you understand that?
Wow, yes.
But it's not mandatory that you're sent to prison at all. Even if you failed to complete ILC, the court still has discretion to place you into community control, or what some refer to as probation. While on community control, you will have rules you must follow. If you fail to follow those rules, the court has the authority to extend the term of your community control or to impose additional, more severe sanctions, which can include local jail time or prison. Do you understand that?
Yes, sir.
All right. Now, you're presumed innocent of this charge. You cannot be sentenced or punished unless you plead guilty or you're found guilty following a trial. Do you understand that?
Yes, sir.
You have the right to trial by jury. If you want, we will impanel a jury of 12 people and require the prosecutor to present sufficient evidence to convince each of the jurors of your guilt beyond a reasonable doubt, or the jury is required to find you not guilty. Their verdict must be unanimous. Do you understand that?
I understand that.
At that trial, you have a right to see and hear all the evidence that the state has against you with the help of your attorney, the right to confront and cross-examine each of their witnesses. Do you understand that?
Yes, sir.
You have the right to call witnesses on your behalf and in your defense. If any of those witnesses are reluctant to come, the court can force them to come by way of subpoena. That's your right of compulsory process. Do you understand that?
I understand that.
You have the right to remain silent at your trial. You cannot be forced to testify against yourself. The prosecutor is not permitted to call you as a witness. You can choose not to testify in your own defense. If you don't testify, that will not be used against you, and I will instruct the jury that they are not permitted to infer your guilt nor anything from your silence. Do you understand that?
Yes, sir.
The burden of proof is on the prosecutor. At your trial, you're not required to call any witnesses nor present any defense, and if you do not, that will not be held against you. Do you understand that?
I understand that.
The standard of proof is beyond a reasonable doubt. That standard applies to each of the essential elements of each charge from the indictment. Do you understand that?
Yes, sir.
Now, you could also waive your right to a jury trial, but maintain all the other rights we've discussed. You could try your case to the court. I, too, would have to be convinced of your guilt beyond a reasonable doubt, or would be required to find you not guilty. Do you understand that?
Yes, sir.
Do you believe you understand each of these rights we've discussed?
Yes, I do.
You understand that when you enter a plea of guilty, you'll be waiving all these rights. We will not have a trial. This is how you want to proceed. All right. Ms. Tranter.
On or about July the 7th, 2025, Warren County, State of Ohio, the defendant Douglas Caldwell on that date did knowingly obtain, possess, or use a scheduled controlled substance, that being methamphetamine, Schedule 2, in an amount less than 0.10 grams.
Mr. Alter, anything on those facts?
No, Your Honor.
Mr. Caldwell, did you hear the statement that she read?
Yes, I did.
Do you admit that what she said is true?
Yes, it is, sir.
And again, you understand all the rights you're giving up by entering a plea of guilty. What is your plea?
Yes.
What's your plea?
I'm guilty.
All right. The court will make a finding that you've made a knowing, intelligent, and...
And there it is, the major turning point of the hearing. The judge officially grants intervention in lieu of conviction and even opens the door for Veterans Honor Court involvement. That's significant because specialty veterans courts are designed to address underlying issues many former service members struggle with, including addiction, trauma, and unstable living situations. But almost immediately after getting this massive opportunity, the hearing takes a bizarre and surprisingly emotional detour. Instead of celebrating, Caldwell becomes laser-focused on one thing, his electric bike. And honestly, you can hear the desperation in his voice. To most people, it may sound strange that he's more worried about a bike than sitting in custody, but listen closely, the bike represents independence. Transportation. Stability. A way to get back and forth to court and treatment. The judge even tries to work with him for a moment by considering electronic monitoring release, but the second the hotel situation becomes unclear, the court pulls back. That exchange is fascinating because it shows the constant balancing act judges face, compassion versus accountability. 1 minute the court is offering help and structure, the next minute credibility concerns start creeping in. And you can almost feel everyone in the courtroom realizing the smallest details can determine whether someone gets freedom or stays in jail.
Voluntary waiver of your constitutional rights, the court will accept your plea of guilty. I am going to grant your motion for intervention in lieu of conviction and order these proceedings stayed pending the completion of the terms of that supervision. So you will be on ILC for up to 3 years, subject to the supervision of the Warren County Probation Department. You're ordered to refrain from the use of any drugs, alcohol, or marijuana in any form.
Right.
I'm going to order you, I have your motion here to be assessed for the Veterans Honor Court, and I have executed that order, ordering that assessment. So I'm going to hold you in the Warren County Jail today until we get that assessment completed and we can find a place for you to live and everything else.
Can I ask you a question? I have a hotel room that I paid for, and I turned myself into the Middletown Police Department with no. I didn't have anything on me. I didn't have.
All right, here's what we're going to do.
I have a motorbike, an electric motorbike. I bought. I'm sorry, I didn't interrupt. I bought an electric motorbike so I could get over here to ILC. And I just bought it for my birthday because it's this month. My birthday's this month, and I went out of my way and bought an electric bike, and it's sitting over there at the Days Inn over in Franklin here. And if I go to Wednesday or whatever it is, it may be stolen. And because I've lost a lot of bikes and stuff, I need to get back to the hotel. I mean, if it's possible, I promise I'll be here on Wednesday. I can give you, I'm giving my driver's license and everything. I have no way of evading or anything, but I can get here Wednesday on my own well-being. If it's possible, please, because I'm afraid I'm gonna lose my bike. I'm not lying. I've lost over 20 bikes in Middletown. And I've just bought this electric bike so I could come here for ILC. Is what I didn't know this is all going to. This is wonderful. I'm happy about getting a place to live with veterans court and stuff. I didn't know this was all.
Mr. Caldwell, again, we're talking about 2 days. How long? What's the jail time credit now?
49 days total, Your Honor.
How long has he been in jail since on this warrant?
8 days.
I don't know what an additional 2 days is going to matter, Mr. Caldwell. The thing is, I need to get.
Because my girlfriend told me on the phone that my bike's still there, but she has no way of getting it because she don't have a key. I locked it up on a wire, the wire, airplane wire stuff. That's where I locked it up on a fence thing over there at the hotel. I hate to sound I hate to borrow the court about it, but I've lost so many of them, and I bought an electric bike finally. I don't like pedaling at my age anyway, but I was going to be able to get here from now on, no matter what. I have a vehicle. This is what my
a bike.
It's an electric bike. It's an e-bike.
You're coming from Franklin? Or
yeah,
Middletown?
Yeah, where the Waffle House is, Commerce Drive. That's where my hotel room is. Yeah, all I got to do is go 123.
All right, I'm going to place you on electronic monitor. I'll order you released today. But if you can't verify that you've already paid for this hotel room, you're not going to get out.
I don't have a receipt with me.
Well, they will. Community Corrections will check with.
No, I mean my bike's there, but I'm not. My room's already up. My room's already up.
Sir, here's the. You don't. Where are you living?
Oh, I've been staying at Days Inn.
But you don't have a room there reserved.
No, right, because I paid for the room.
Look, I'm not going to continue. Look.
I'm sorry. Okay. I apologize.
I'm going to hold you till Wednesday. We'll discuss some options on Wednesday when you're here.
In the end, this hearing became far more than a standard felony plea. The court gave Douglas Caldwell an opportunity many defendants desperately hoped for, treatment instead of immediate conviction. Through ILC and a possible Veterans Honor Court placement, the judge signaled that rehabilitation was still on the table, but only if Caldwell follows the rules and proves he can stay compliant. What makes this case memorable is how human the entire exchange felt. Beneath all the legal terminology, deadlines, and supervision conditions was a man clearly worried about losing the few possessions and pieces of stability he still had left. The judge showed patience, but also drew a firm line when the details stopped adding up. That balance between mercy and responsibility is exactly what makes courtroom moments like this so compelling to watch. Now I want to hear from you. Do you think the judge handled this situation fairly, or should the court have released him to retrieve his belongings? If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.
For Veterans.
Okay, I'll just call my girlfriend, tell her to guard it.
Yeah. Okay. All right. I'll see you
Sorry.
Wednesday. Thank you. Add him to the docket for Wednesday. Just hold him today.
Okay.
All right.
Thank you, sir. I'm sorry for taking off on a tangent.
You're fine.
Thank you, guys. I'll see you Wednesday.